Good afternoon, everyone. This is Kathy Purdy. I am the Marketing Supervisor at Schoeneck King. I'd like to welcome you to today's coronavirus webinar discussion. Two quick items before we get started. Please enter your questions in the Q&A box located at the bottom of your screen, and we'll do our best to get to those as time allows. And if you would take a moment at the end of today's webinar to complete the brief survey, we would greatly appreciate that. So to get things started today, I'm going to turn it over to Pete in our Syracuse office.
Thanks, Kathy, and good afternoon, everyone. We continually are following these updates and, kind of thinking, at least initially, we were thinking that we, at some point we, kind of run out of stuff to talk about and think about. But so far that does not appear to be the case. So we're going to plan on continuing to do these on a weekly basis for the foreseeable future. We've got a full program today. We're going to talk a little bit about the Families First Coronavirus Recovery Act. We're going to talk a little bit about some, reopening concerns and operating and some of the questions that keep arising there. We're going to talk a little bit about some changes at the State Division of Human Rights that are COVID related. And then finally, we're going to continue to monitor what's going on in Albany. So hopefully you can stick with us this afternoon. We're going to start it off today with Stephanie Fedorka. Stephanie's in our Syracuse office, and she's going to talk a little bit about the Families First Act. Stephanie, take it away.
Thanks, Pete. Good afternoon, everyone. Thanks for joining us. I'm going to provide a quick update on the FFCRA. Most notably, there was recent guidance from the U.S. Department of Labor issued on July 20th that added 4 more questions to the FAQs. So now we're actually up to number 97. There's lots of FAQs out there, but we'll go through each of those 4. Just a quick recap, the FFCRA is the Families First Coronavirus Response Act. It applies to employers with 500 or fewer employees and certain public employers, and it provides benefits for qualifying employees. There's 6 qualifying reasons that employees may take leave under the FFCRA. But the 2 main components are going to be the paid sick leave and the paid expanded family and medical leave. So starting off with FAQ number 94, my employee used 2 weeks of paid sick leave under the FFCRA to care for his parent who was advised by a healthcare provider to self-quarantine because of symptoms of COVID-19. I'm concerned about his returning to work too soon and potentially exposing my other staff to COVID-19. May I require him to telework or take leave until he has tested negative for COVID-19? And the answer is lawyer's favorite answer, right? It depends. And in addition to that, the DOL provides a little bit extra in determining whether or not you can do this. An employee returning from paid sick leave has the right to be restored to the same or an equivalent position, of course, minus the exceptions that are actually listed in FAQ number 43, in case you're curious and you want to look back. You can temporarily reinstate the employee to an equivalent position requiring less interaction with coworkers or require that they telework. Again, they refer to that public health emergency and that concern that someone has been exposed potentially to someone with COVID-19. The employee must still comply with job requirements that are unrelated to having been out on paid sick leave. You can require any employee who knows that they have interacted with someone who tested positive for COVID-19 to telework or take leave until they've personally tested negative for COVID-19 themselves, regardless of if they've taken any other kind of leave. The same policy would apply to employee returning from paid sick leave. However, it's important to note that an employer cannot require an employee to telework or be tested for COVID-19 just because the employee took some leave under the FFCRA. So moving on to FAQ number 95, I was working full-time for my employer and used 2 weeks, 80 hours of paid sick leave under the FFCRA before I was furloughed. My employer said I could go back to work next week. Can I use paid sick leave under the FFCRA again after I go back to work? And the simple answer here is no. And why? Why is that? Because employees are limited to 80 hours total of paid sick leave. So an employee, here's the difference though. If an employee took fewer than the 80 hours of paid sick leave before they were furloughed, they would be entitled to use the remaining hours after returning from furlough, of course, contingent upon them meeting some other qualifying reason. FAQ number 96. I have an employee who used 4 weeks of expanded family and medical leave before she was furloughed. Now I'm reopening my business. When my employee comes back to work, if she still needs to care for her child because her child care provider is unavailable for COVID-19 related reasons, how much expanded family and medical leave does she have available? So this one requires a little additional explanation that the Department of Labor spells out for us. Under the FFCRA, recall that an employee is going to be entitled up to 12 weeks of expanded family and medical leave. Again, it's those 2 weeks of paid sick leave and then the additional 10 weeks under the expanded family and medical leave. So it's 12 total for this particular qualifying reason. The time spent on furlough does not count as time on leave under the FFCRA. So here you would do the 12 total weeks of entitlement that this person would get or be entitled to, minus the 4 weeks used. So this particular employee situation would have 8 weeks left. They do note that if the reason the employee needs leave changed during the furlough, you treat the post-furlough request as a new leave request. So you can ask for appropriate documentation relating to the current reason for leave. The example that they provide in the FAQs is before the furlough, this employee may have needed the leave because her child's school was closed. Now that we're in summer recess, she needs the leave because her child care provider, for example, maybe a summer camp, is closed due to COVID-19 reasons. So although similar, it's a different reason, so you can ask for appropriate documentation. And then our last one, FAQ number 97, my business was closed due to my state's COVID-19 quarantine order. I furloughed all my employees. The quarantine order was lifted and I'm returning employees to work. Can I extend my former employee's furlough because he would need to take FFCRA leave to care for his child if he's called back to work? And the simple answer here, again, is no. And although, straightforward to some degree, you can't discriminate or retaliate against an employee or prospective employee for exercising or attempting to exercise their right under the FFCRA. So the employees are going to have that right to take that paid sick leave or the expanded family and medical leave for a qualifying reason until they've exhausted their entitlement. You can't use the request or an assumption that the employee would need that leave or make a request for the leave as a negative factor in an employment decision, such as recalling employees from furlough. And that's all I have for you on the update for FFCRA.
Stephanie, thanks. I think this is kind of timely in the sense that the FFCRA was a big topic of discussion. Back in April, May, everyone was trying to grapple with it. I think people got their hands around it and a lot of the leave, reasons for the leave abated. I think this fall, with back to school and some of those issues, we're going to see a lot more focus on it again. So thanks for the update on that. Let's turn now to Adam Masterleo in our Syracuse office. We've really got two presentations today, on New York Forward, operating. And the first is from Adam. He's going to talk about some of the things that we're seeing, some recent nuances and twists. Adam, take it away.
Hey, thank you so much, and thank you for having me again. We have continued to counsel clients through the various issues associated with COVID-19. And, the questions continue. The questions we can really narrow down into a number of specific areas, reopening plans being one of them, one of the hot button issues right now. We're not going to talk about those, but also there's a category of questions that we're fielding as it relates to operations or operating businesses. Now that many of our businesses are open, there are some issues that keep coming up. So the first one I'm going to talk about is investigation. The state, as we've talked about before on these webinars, the state has made it very easy for people to file complaints about businesses that they feel are not operating in accordance with the state's guidelines. So what this has led to are investigations of businesses when complaints are made. The typical way that we've seen this come up is a complaint will be made to the Department of Labor either through filling out a form online or calling. The Department of Labor will then involve the Attorney General's office as its enforcement arm, and businesses will receive correspondence, either letters or emails from investigators at the Attorney General's office, asking them about the complaints. These letters or emails from the Attorney General's office are usually very accusatory. They'll say that we've received a complaint that you're violating or you're not complying with the guidelines. Here are the specific ways that you're not complying. Please provide us with a written response. Typically, the written response is required in a very short period of time. So you have to be ready either to respond yourself or to contact your attorney to help you respond to the Attorney General's office. In the cases that I've worked on, typically the way that we've done it is we have prepared our response, we've submitted our response, and then that's been the end of the investigation. Most of the clients that I've worked with have all been complying with the New York State guidelines. So the response is more clarifying to the Attorney General's office why and how we've been complying. So that leads me to some recommendations for best practices if you receive one of these inquiries from the Attorney General's office. You need to make sure that you have your plan available, your plan is clear, and your plan can be provided to the AG's office upon demand. So the first thing, whether it's a complaint about not requiring masks like you should or occupancy violations, you need to make sure that the details of your plan are clear. You have the plan available to provide. Another suggestion is that if the complaint, for example, is about mask requirements, if you have signs up at your facility that say when people should be wearing masks, take pictures of those signs. You're going to want to attach them. You're going to want to provide any proof that you can that you are actually complying with the guidelines. So that could be in the form of photographs, that could be in the form of signs. If you have, for example, we had a client who was accused of not complying with mask requirements at their store. And interestingly enough, a couple of weeks before, the client had been contacted by someone saying they didn't want to wear a mask and asking if the store was really going to be requiring it. We had responded that yes, we are requiring it. And so when the AG's office came calling a little later, we were able to say, look, we took a step that was potentially harmful to our business to make sure we were enforcing our mask mandate. There's no way we haven't been doing that. So developing and having proof that you are complying with your plan is going to be another topic, operating topic that I think is worth covering, especially given the situation that Pete just talked about. We're entering return to school season, but almost all schools are not going to be operating at full capacity. So if you have school-age children, or if your employees have school-age children, there's going to be a whole new round of childcare issues that you're going to have to deal with. I think that it's at this time, I know that most businesses have got a handle on this early on, but at this time it's going to be important to review your policies. Make sure that you have a set procedure in place for employees to request leave related to either childcare or daycare not being available. We have worked with clients to develop forms that they use for their employees to fill out when they are requesting any kind of COVID-19 related leave. Those are a good idea because it will force the employee to identify specifically the reason or the basis for their request for leave. If they are requesting leave as a result of a school closure or a daycare closure, they will have to provide you information on that form regarding things such as the age of the child, what daycare or childcare is not unavailable, and they have to say that they're unable to get replacement childcare or daycare. So make sure you have those processes in place. Make sure it's clear who these requests will be submitted to. There should really be one repository for all COVID-19 related requests, whether it's your human resources director or someone specific at your business. Employees should know who they are supposed to communicate with about that type of a request. So that's another issue, operating issue, that we think is important to highlight right now as we're entering back to school season. The last operating issue that I'm going to talk about is the one that we are still receiving the most questions about, and that is the travel quarantine. You know, the state put this out with good intentions, and unfortunately it has caused quite a bit of confusion for employers throughout the state. We have talked on these webinars quite a bit about the essential worker exemption from the travel quarantine requirement that allows essential workers to go to work under certain circumstances. I wanted to highlight something that has come up recently about what constitutes an essential worker for the purpose of the travel guidance. As many of you know, the Empire State Development Corporation, early on in the process, the COVID pandemic, put out a list of what the state is considering to be essential businesses. And that's found on the ESD website. In addition, as we all know, there are certain professions or jobs that were considered to be essential, whether or not they were working for an essential business or not. For example, trash collection or security guards were considered to be essential. Under the travel guidance, it defines essential employees as individuals who are employed by one of those businesses that's been identified by ESD as essential. But then it also says that essential employees are employees who would satisfy the specific protocol for testing that's referenced right in the travel guidance. So you're going to have to look at that guidance that's referenced in the travel guidance, and there's a listing of specific occupations that may be considered essential. So you may have an employee that qualifies as an essential employee that you don't know about because you haven't consulted the list. So take a look at that. It's referenced right in the travel guidance and linked right from the travel guidance. I noticed we had a question early on, Pete, about the a travel question. So the question was, I have an employee who went on vacation to a particular state, returned from the state. Later on, after they returned from the state, that state was added to the list. And the question was, does that employee need to quarantine? The answer is no. The Q&As that accompany the travel guidance make it clear that the travel states, or the states, or excuse me, the quarantine requirement is not retroactive. So in the scenario that you referenced, the employee would not need to quarantine because they returned from the state before it became a hotspot. So that's an example of one of the types of questions that we are continuing to get on the travel guidance. Pete, that's about all I have for right now on operational issues. I know we have Sam Burgess coming up a little later to also talk about operational issues facing employees.
Yes, thanks, Adam. You know, one of the themes, I guess, and it may be a little frustrating to people, but it's worth mentioning, is that each one of these issues really needs to be analyzed individually. Again, this guidance that's been issued has been written pretty quickly. In some cases, there may be some intentional ambiguity in the guidance. In other cases, it may be unintentional, but it immediately becomes apparent. And working through these situations can be a little bit difficult, but really that's really what you have to do, because the permutations are almost endless. Essential workers, where are they going, for what purpose? All of these questions may influence the outcome. So
yeah, and I would point out that of all the guidance the state has issued, this travel quarantine guidance has raised probably the most questions. So definitely check with an attorney when you have a question about this to make sure that you're interpreting it correctly.
Okay, let's go to Sam. Sam's going to touch on operating issues as well and just kind of do some FAQ. Sam, take it away.
Thanks, Pete. So I'm going to follow up on a lot of what Adam said on the operating issues. We're going to get into a couple of topics, not necessarily specific questions, but a few topics that are the basis for many of the questions. Obviously, Adam already talked about the travel advisory, quarantine there, but the few other scenarios that keep coming up revolve around a couple topics that I'm going to try to get into here. So first, a lot of the questions come around, what to do at the workplace itself. How are we going to handle a positive case? How are we going to handle people coming back to work when we're continuing to try to increase our occupancy? And the first thing we can say is, go back to your workplace safety plan. Now time has passed since the guidance was put out, whatever industry you're in, whether it was May or June, some time has passed on that. You've likely been back to work for a period of time. And start looking through that to make sure everything is fleshed out. It may be that, the guidance was broad and you didn't know how to apply when you got back to your own workspace. So put some scenarios out there. Put some scenarios out, and test your policies. Test, someone comes with a positive test. Is your policy cover that? Someone is asymptomatic in your workplace. Is it set up to cover how you're going to handle that? Is it set up to cover how you're going to handle masking of individuals that are employees and customers? The time has now passed that we need to make sure the policy's on point to handle that. Take the discretion out of some of the decisions so they don't have to be made on an ad hoc basis, so that you can make them based on your policy and make them consistently for the future. So with that too, part of the workplace safety plan, was the occupancy limits. How many people are going to be in the office? How are you going to handle the workspace? Your social distancing, and what those limits are. Again, even though we're in phase 4, those occupancy limits haven't changed for the prior phases. So as a general rule, most of them are the 50% capacity. And again, that's the 50% capacity as set forth in your occupancy. It's not 50% of your workforce. So if you still have capacity and you would like to bring people back, again, you should start looking at what has worked for you, what hasn't worked for you, and how you want to bring people back. How are you going to determine what to bring people back? And another issue coming off of that, also kind of touching on what Adam talked about with the issues we're going to have with school and childcare coming up, is remote work. Presumably many people have been engaged in remote work in some capacity since March. We had to go in rather quickly to develop how we were going to allow people to work from home, what kind of expectations there were going to be, and likely nothing was put in writing. It was probably everyone went home. If we can work from home, we're going to try to work through it together. But now, as we've been home for 4 months and people are starting to get back to the workplace, if you're going to be flexible and have anyone at home, you should develop a workplace or a remote plan. That plan's got to outline your expectations of your employees. Who's going to be eligible for it? Is it going to be everyone? Is it going to be based on their nature of their work? Is there going to have to be specific circumstances that are going to allow for the remote work? Is there set times or a limit on how much remote work they can do? You're also going to want to make it clear what the responsibilities are of an employee if they're going to be working from home. Tracking their hours, collaboration, signing in, scheduling meetings with either other staff, other employees, their supervisor. We've had the time to look at what's worked and what hasn't worked. So you should go back to that and develop a policy of how you're going to handle the remote work going forward. Make sure there's a way that you can track production. Again, people are saying they're productive at home, but make sure there's a way that you can make sure they actually are, that they're getting what needs to be done, completed in a timely manner. Also, with that, make sure you have other policies in place. Make sure they're aware of your other policies and procedure, whether it's the confidentiality of, employee records, client data, whatever it may be. you need to make sure that's clear when you're talking about remote work. And then a big one coming with the childcare situation is, how are you going to handle the childcare? And this is a big hot button issue, but are you going to require that there's no distractions? You know, I'm aware of some bigger institutions out there that are requiring employees to sign an affidavit saying that they are not the sole provider or sole child care provider when they're working from home. So, I mean, that is obviously raises a whole host of issues, but that is something to think about when you're developing these plans. Do you need your employees when they work from home to be there for a set time from 8 to 5 or 9 to 6? Or as long as they get work done during a certain time frame, it's okay. So that is another hot button issue to deal with when we're talking about our operating issues. So what it comes down to is there's a lot of operating issues that continually come up, and they're constantly changing, and they're specific to your own circumstance, your own situation. But a lot of them do come back to the policies and procedures that you've developed over the course of, you know, your existence, in particular the last 4 months. So make sure those policies are still on point and still work for what you're trying to accomplish. And with that, Pete, that's kind of what I have at this point, and I'll turn it back to you.
Okay, Sam. We got some interesting questions here, including sort of a general question of, you know, how do you track productivity? And I guess, you know, that is, you know, one of the questions here in terms of, you know, when you're operating remotely in part, in person in part, you know, people are back and forth perhaps. And again, I think these are things that people are going to have to sort of analyze with respect to their business and try and figure out, you know, what are the metrics and how can you track it? Any thoughts on that?
Yes, I mean, I agree with you there. I think it's very industry specific on what your industry does and what you're trying to accomplish. But some ways you've seen is, you know, the check-ins to see what has been done. You know, if there's a task that they have to complete, or if there's a list of tasks they have to complete, it could be a check-in on those. Or you can set up a checklist of things that are to be done for a week, a day, and have a follow-up with a supervisor, depending on how closely you work with that supervisor. I mean, it's not one size fits all, and there's certainly not a clear-cut answer to say, okay, you can tell the person's being productive, but you can also look at, you know, if it's a computer-based job, you know, they're away time from their computer to make sure that they actually are on the computer and they are logging hours and being productive when they actually are on the computer, to track kind of their history and their access.
Great. Okay. Very good. Thank you. Then we're going to turn now to Kate Mcclung. Kate's in our Rochester office. And, you know, unless we forget, you know, that kind of things go on, including our, you know, claims before the State Division of Human Rights. Kate's got some COVID-related angles, as well as perhaps some tips on some of the old things as well. Kate, take it away.
Thanks, Pete. So just like all of our businesses, the Division of Human Rights has had to come up with alternative ways to do things in response to COVID-19. So initially in March, when there was the big scramble, as places were closing down and the governor was restricting how many people could be at work, the big changes at the time were that they started doing fact-finding conferences during the investigation phase by phone primarily. And all of the hearings before the administrative law judges, which are generally done in person, were all adjourned. And so now there's quite a sizable backlog of hearings as a result. So more recently, though, there have been a few interesting changes. So first, the division has implemented a fast-track investigation procedure. And this is apparently being applied for any case that has any connection to COVID. So if you have an employee who says that they asked for an accommodation with respect to COVID and it was denied and they bring a claim, that would get sent to the fast track, anything at all related to COVID. And so typically the investigation procedure is the employee files a complaint, it's sent to the employer, the employer has an opportunity to respond, and then usually several months later, the investigator is assigned and in most cases has the parties participate in a fact-finding conference. Well, if you have a case that's assigned to the fast track, the investigator is assigned immediately after the complaint's filed. They will schedule a new conference called a Conciliation Conference, and that may be scheduled before you even have a chance to respond in writing to the complaint. I had one of these last week. The Conciliation Conference was scheduled about 13 days after the employer received the complaint, so a pretty short window. At the Conciliation Conference, the investigator will talk the parties through settlement options and see if they can reach a successful amicable resolution. If not, the investigator proceeds immediately with the fact-finding conference. So, what are the takeaways from this new procedure? You may not know right away that a complaint's assigned to the fast track. You may not find that out until a week later when you get a conciliation conference notice, and at that point, you may just have a week until the conference is scheduled. So it makes it really important that if you get a complaint from the Division of Human Rights, you contact your counsel immediately and you start figuring out how you're going to respond immediately, because you may be going to a conciliation conference very soon thereafter. So you may not have the luxury of a really long investigation before you have to go to the fact-finding conference. Now, we have seen some cases get assigned to the fast track that didn't really seem to be related to COVID. It seemed a bit of a stretch. So don't assume just because the complaint doesn't reference COVID that you're not going to get put on the fast track. You should assume that you're going to face the fast track and contact counsel, get your ducks in a row so that you know how you're going to respond to questions at a fact-finding conference ASAP. Another big change is with respect to hearings. So as I mentioned, they have a pretty big backlog of hearings right now since they've been adjourned for the last 4 months. And they've now set up video conference capabilities so that they can do these hearings by Zoom. But as part of an effort to deal with the backlog, they've started scheduling preliminary conferences. So for those of you who have been unfortunate enough to go to a division hearing before, usually you get a hearing notice and it says these 2 days are your hearing. And when you show up at the beginning, you do a preliminary conference. Well, now they've started scheduling the preliminary conferences in advance by telephone, and you're expected to be able to discuss when the hearing should be scheduled at that conference. But for all other purposes, it's the same as the preliminary conference when it's part of the hearing. So before that telephone conference, you have to exchange lists of issues, exhibits, and witnesses with the other side. You have to provide your written answer to the complaint beforehand that lists all of your affirmative defenses. So that's another change that we've seen. And certainly the fact that the hearings are going to be by video now is going to change the strategy a little bit. In addition to doing witness prep for their testimony, you're going to really want to do some specific prep about ways to promote your credibility as a witness, even when you're appearing by video conference. And there's some very specific strategies for doing that. You'll also want to make sure that you're comfortable with the technology, because normally in an in-person hearing, it's very easy to deal with exhibits. You're just handing around pieces of paper. But when you're all in separate rooms connected by video conference, you have to rely on the technology to enable you to do that. And so you want to make sure that you're prepared for that ahead of time. That's all I have, Pete.
Okay, thanks. Interesting. And one point I would just, emphasize that you made, that is that I believe these changes, the conciliation conference from the get-go, potentially coupled with a fact-finding conference, almost any connection to COVID whatsoever will trigger that conference, and that's been confirmed by the division to us. And we may see after this is over that become potentially more prevalent. It used to be kind of the way they started off their investigative conferences years ago, so we'll have to see where that goes. Okay, next up is Katie Anderson. Katie's been, following the developments from Albany. We've already there's a lot of people on the chat here who are very interested in the list of states, and have gotten a quick preview of some of the things Katie's going to talk about. But Katie, take it away.
Let's unmute this and let's go. So this is just what we're going to run over today. Obviously, we will be spending a bit of time talking about the travel advisory, but just so you know what's coming up. First thing to really look at, and I apologize, I made one mistake on this, but let's go over really quickly the states that were added today. 2 states were added today to the travel advisory, Kentucky and Illinois. 2 territories were also added, Puerto Rico and Washington, D.C. My error in this map, which will be corrected in the article that we're going to be putting out shortly, is Colorado is not a quarantine state. All right, so don't screenshot this and think that it's the, Bible. It's not. It is, Colorado is fine as of right now. But the thing to really look at here is, especially with Puerto Rico, again, there are 1 million New Yorkers of Puerto Rican descent. That's huge. And that's going to really create some issues going forward. One thing to look at as well is looking towards next week and the weeks after. Pennsylvania's rate has been rising and it's concerning. There is a possibility that Pennsylvania could be added next week. If Pennsylvania is added, that would be the first border state, obviously, to New York. That comes with a host of issues. But remember that essential worker distinction that Adam spoke about, that will likely continue. If Pennsylvania is added, we don't know if they're going to put out more guidance. I would hope that they would put out further guidance since, we share our largest border is shared with Pennsylvania. So that's of concern. One other thing too about the travel advisory states. So Kentucky was added today, right? So say you had an employee who was flew in from Kentucky this weekend. So 2 days ago, they arrived from Kentucky. It applies prospectively. So it applies as of tomorrow morning at 12:01 a.m. So any flight from Kentucky that gets to New York before 12:01 a.m. On Wednesday is good to go. Otherwise, you have to abide by these quarantine restrictions. So that's, just keep that in mind going forward. The other thing too, there is the essential employee exception. Take a look at that guidance document. We have an article that really walks you through what you need to know about the travel advisory. So please take a look at that. And at the end of this, I can throw that in the chat, even though I am the last one. What else is going on in Albany? So let's first start with what the governor just was going over today. This is of interest to New York. The governor has extended an offer to Major League Baseball to host all baseball games within New York. So if you are a Mets fan like myself, if you're a Yankees fan, all right, and you love the Subway Series, well, get ready because we could be having a lot of Subway Series in New York. He's offering it to use all minor league stadiums, to use all college stadiums in New York, to kind of create the NBA-like bubble. So we'll see how that's going to go. There is a possibility that could happen. So keep that in mind, especially if you operate a baseball park. It's might be a good time for you. Looking also at these executive orders. This executive order really extended a lot of these other ones. And I include this chart here. I didn't update it because there's so much data that I can't fit it all on a slide, but 202.53 extended 202.45. It extended, pretty much everything got extended last week. So for another 30 days. So going forward, that's going to be, something to look at. What else is going on in Albany? Things are happening in Albany. Let's just put it that way. The state legislature met last week and they held another remote session. Lots of the things that they passed were non-controversial local measures, right? A lot of these controversial measures are being placed to the side for the year. But what's really going to happen, and before I go into the health facility immunity rollback, I just want to, pause for a second to talk about the context of what's happening with the state legislature right now. The state legislature is meeting again this week, also remotely, and then they're going basically on a break until we figure out what's going on with Congress. Congress right now has two different proposals for another relief bill. The Senate Republicans' relief proposal has up to $1 trillion in relief money. The House Democrats, theirs is $3 trillion. So that's a significant amount of difference in the relief bills that would impact unemployment. That will impact, a host of issues. There are talks about another round of PPP. And so that's going to be big. And the biggest thing for New York is whether New York is going to get money. And whether local governments are going to get money from Congress. If Congress adequately funds New York State, the state legislature likely won't meet again. If Congress does not send federal money to New York that's adequate to cover what's happening, the state legislature is going to meet again, and there are going to be some really tough decisions that are going to be made. Generally, you don't pass a tax during an election year, but 2020 has been anything but a general year. They are going to be strongly looking at, all of their options, including a tax on stock trades. So New York City already taxes stock trades, but New York State would then take a chunk out of every stock trade. So that's become a more popular thing. But really, what matters to the state legislature is if Congress is going to pass relief that's going to help New York, then we won't see them again. But if they don't, then we'll see them again. This health facility immunity rollback that passed both the Senate and the Assembly last week, this rolls back what was in the budget. What was in the state budget this year said during COVID, during this public health emergency, it largely suspended lots of medical malpractice. And this rollback of that says, the immunity only extends to COVID-related cases. Not so, say I break my foot and I go into the doctor's office and, something horrible happens, I would still have a case at that point. It applies prospectively, so it applies from the date that it becomes a law. What's interesting is that it was sent to the governor on the 24th, I believe. It was sent to the governor last week, and the governor has not signed it yet, has not vetoed it yet. If the governor doesn't act on it within 10 days, it becomes a law. That's the New York rule. So we will be watching that closely to see, and it only applies going forward. So that's one thing to remember. There are also significant changes that are likely going to take place regarding redistricting, which, concerns each and every New Yorker. One big thing to look at as well is the State Liquor Authority and the New York State Police. They have been going into lots of facilities downstate and issuing violations. There were over 100 violations issued between Friday, Saturday, and Sunday. They visited the state police and State Liquor Authority visited 644 businesses yesterday. So they are really upping their enforcement. They're focusing it downstate, and they're focusing it also on, big events. There was a chain smokers concert that occurred in Southampton over the weekend. That really drew the governor's ire. So we will see where that goes. And I believe that is it for me, unless I have another surprise slide here. And otherwise, we are done.
Katie, stay with me for 1 second, because I want to just summarize this travel advisory. We had a lot of questions on it. I think we covered it in a couple of different dimensions, but let me see if I can summarize it and have you jump in. So if you travel to one of these states that's on the list, and the list is constantly changing and frankly growing, you need to quarantine for 14 days when you get back. There are limited exceptions, what I would call it, for essential workers. That doesn't mean that you're not still supposed to quarantine, but it does allow you to work. And depending on what category of essential worker you're in, a healthcare worker versus other essential workers, and depending on whether or not you have reason to believe you've been exposed or not, that is another possibility.
Yep.
Slightly different rules will apply to your ability to work, but you should be able to work provided you're an essential worker and you satisfy the rules for each of those situations. Have I kind of summarized where we are in terms of the broad general rules?
Yeah, that's broadly speaking, that's it. The exception, remember the exception to this is that if you're an essential worker, you may be able to come back to work. That's not a hard and fast rule, especially if you have potentially been exposed to the disease. You were in prolonged contact with somebody who had COVID. That's really concerning. So, I know lots of you here are the people making the decisions for your places of work about what are we going to do? Are we going to bring these people back? Always the safest option with abiding by New York would be just tell everybody that they have to quarantine for 14 days. That is the baseline safe option. And then these further distinctions exist.
Yes, a very good point in terms of, employers potentially exercising their discretion to go beyond. The other point is that if you're not in one of these states for at least 24 hours, it's not going to apply to you as well. So we'll continue to answer these questions, and people will, I believe, continue to come up with new scenarios because our employees are, doing a lot of different things and creating a lot of different issues for us to figure out. So thanks everyone for being with us. We appreciate you sticking with us today and talking with us every week. We'll see you next week. Everybody stay safe.